All right, now we're going to talk about a case out of Kentucky where it's like a Bob Marley song. A sheriff who shoots a judge. That really happened. I mean, there is actual footage of the sheriff walking into the judge's chambers and shooting him. I don't know that we're going to see the whole thing, but it's so clear what he did. He continues on, because I've seen the whole video, and you can go to YouTube or Google, whatever. You can see he continues to pump the bullets into the judge. There is no question that he did it. He surrendered. He's been in jail for about a year now, since September. His defense lawyers want to get him out on a $50,000 bond. We're going to talk about that. Welcome back, my wonderful experts. Listen, guys, Kentucky, Whitesburg, it's a tight community there. The sheriff, he's a former sheriff, Sean Mickey Starnes, goes into the chambers and he just starts pumping bullets into Judge Kevin Mullins, and he kills him. He was dead right on the scene. These guys were friends for years. In fact, the shooter was the bailiff for the judge for a number of years before he was elected to serve as sheriff in 2018. Wow. Phil.
Yeah.
What is going on here?
Well, that's a great question. Look, there's no question, obviously, that the judge was killed by the sheriff. The real legal question is, was it murder or was it some other crime, maybe less than murder? I will say parenthetically, the defense counsel for the sheriff has more than once said, and I'm just summarizing, he said there's going to be more to this that will make it all make sense. And there's some allegations that maybe there was some kind of small town sex ring going on that the judge was involved with, and perhaps the judge was involved with the sheriff's daughter. There's some of that kind of stuff going on. So we're going to have to wait and see how this unfolds. But the question legally, guys, is this a murder, or was this some type of manslaughter because he had or temporary insanity, which could be an acquittal? But if this is like the irresistible impulse that the sheriff just could not resist pulling that trigger due to something that triggered him, no pun intended, then he could qualify for some type of diminished capacity defense or even an outright acquittal if the jury believes that that's the case. So it's going to be very interesting to watch this unfold.
Number one, I think the pun was intended. And number two, Ashley, all right, this is your client, hypothetically. It's not, but let's say it's your client. You enter a not guilty plea, which he already did. What is the very first thing that you're doing to try to help him?
Trying to get him out on bond. I mean, that is the number one thing you've got to do. You try to get him out on bond and try and get all the evidence preserved. And I think a lot of people don't realize that, bond is one of those things that is really vital for a good defense. I need my client out. I need them helping me. I need them gathering documents. I need them going to their phone company and getting me phone records. I need them, giving me information about witnesses. It is really hard to defend someone who's in jail and doesn't have access to anything. So that's one of the things. I think, the next thing is you investigate. And, when I read about this case, it sounds like it's about to be the next best Netflix documentary. There's sex parties, there's swingers. This whole community apparently was swinging. This judge was involved with litigants in his courtroom. And then the most damaging piece of evidence came out at the probable cause hearing, where one of the detectives said right before this judge was shot, they were looking at text, and there was a text from the shooter's daughter in the judge's phone. So just with all of that, I would be doing some serious investigation into what really was going on here.
It's hard, Phil, to talk about bond, which is what I'm talking about right now, when Ashley just talked about sex. And I totally want to jump into that, which we will. But let's go to bond, okay? What is your argument from the prosecution's perspective? Because apparently all their arguments are due by September 2nd. As of this show right now, there has not been a ruling. As far as I know, the guy has been in for almost a year now. What do you argue? I mean, the defense is saying he's not a danger to the community and he's not a risk of flight.
Well, I think the defense is actually right. This is where you want me to put my defense hat on, but you want me to make the prosecutor's case. All right, so the prosecutor says, look, Judge, this is a serious crime. It's a capital crime. He could be facing life in prison. That gives him a motive to try to flee the jurisdiction. He's got supporters. He's got people that have voted for him. He's got a network of people out there that could help him orchestrate an escape. It's a small town. There's a danger that he's going to influence witnesses. He's going to be talking to people. He's going to be doing things that defendants on bond are not allowed to do if you release him. And so that's going to be, I think, the crux of their argument. He clearly has ties to the community, but those ties might also be the reason that he would be a risk to perhaps influence these witnesses and people in the community. So that's the state's argument. However, I personally think he should get bond despite the gravity of the case. It is unusual in a murder case, although certainly not unheard of, for people to be released on bond. So we'll see how that plays out.
Wow. Phil, the ever-loving prosecutor, somehow said the guy should be getting out on bond. Phenomenal. And by the way, Ashley, the other reason why I love my clients getting out on bond, other than the fact that it's a pain in the butt to have to go visit them in the jail, I love for them to come to my office, but as a practical matter, isn't it great when the jurors are having lunch in the one crappy cafe in whatever courthouse this is going to be at, and the defendant's sitting right there with you?
Oh my gosh.
Tell me, Ashley.
Oh, you walk in and out the same door.
Come on, you're sitting there with them, right? They're holding their wives' hands even if they hate each other, right? It's theater. Tell me about that.
It is total theater. And I mean, you're putting your arm around your client, you're walking in and out with them. It is so much better because it's a stamp of approval. It's the same reason that we don't allow defendants to come into court in shackles and jail clothes,
right,
because that prejudices you. So it also prejudices the jury for you if your client's actually out on bond. It's just so much easier though. I mean, one of the biggest difficulties is these stupid jail recordings. You can't have any conversation. And look at Donna Adelson, snitches. My biggest fear is that some snitch is going to lie and say my client said something in jail, and then I'm going to have to defend against some snitch. I don't have that if my client's out on bond.
Right. All right. So Phil, you've entered a not guilty plea. You tried to get your client out on bond. And now you're talking about possible defenses, and the defense has already said we're talking insanity. Now, it ain't self-defense, right? And it's not a whodunit. No. So you think that that's the right way to go, yes?
I think it's the only way to go because obviously we've seen the video. There's overwhelming evidence that he did the act, but the other part of it, to have a crime, you've got to have what's called the actus reus. That's Latin for the guilty act. But you also have to have the mens rea, which is Latin for the guilty mind, or what we call the culpable mental state. In this case, he clearly did the act. So the defense has to be focused on the mental state. And if he didn't have the necessary intent because of some defect, because let's just say it was this irresistible impulse. That's sort of what the common law would call this temporary insanity, right? Did he have this irresistible impulse that he just could not stop himself from firing that weapon because he was so upset by something he had just seen or something he had just heard? Then there's a middle ground too, which is manslaughter, which is like this, it's a crime of passion. It's not quite to the point of being an irresistible impulse, but he was so provoked by something that he just was so caught up in the passion of the moment that he couldn't help himself. And that might gravitate towards a manslaughter. And I want to say that they're probably talking about a plea deal somewhere in that ballpark if a plea deal happens.
All right. Well, Ashley, you want your client to walk. They're paying you the big bucks because you want to actually have him do no time, because the sheriff doing time in prison at all, that is rough time.
That is big bad.
So one thing you're going to pull out of your playbook is trashing the victim, right? And before I ask you to give your thoughts on that, let's go to clip number 11. They've already started to trash the victim because apparently the victim, this judge, might have been having some sex with some people. Let's take a look at that clip.
I was kind of like informal intern in there, like learning office management and stuff. And I went over to his office to learn how to take a deposition. And that was the first interaction that I had with him as far as the sex and stuff goes.
What happened?
I gave him oral with my shirt pulled down, and whenever we were done, he threw money in my face, told me to clean myself up, and reminded me that I knew better than to tell my sister.
And what was his job at that time?
Assistant Commonwealth Attorney. And then after that point, that's when he started introducing me to his friends, the other lawyers, and we would do sex parties and perform shows and have sex with them for money.
Did you feel like you could say no?
No. No, and they would make sure to make you feel as small and degraded and belittled as possible to take your power away, you know? Also, like, I have to say, like, we were having fun too, you know? Like, we were doing drugs, we was doing coke, doing a lot of cocaine, partying, you know? Like, it wasn't like they were just like, they weren't raping, like, physically, like, you know, what people think about when they hear the word rape. It was consensual. The whole town's doing it, you know? Nobody cares. They're all swingers. It's all a big party to them. It was just, like, so normal.
Did you ever have sex with him after he became judge?
Yeah. Yeah.
When he was the judge?
Yes. I've had sex with him in the chambers. I've had sex with him upstairs.
You had sex in the chambers?
Yes.
Ashley, oh my goodness.
Crazy.
Right? I'm going to make sure that my Netflix subscription is renewed for sure, because this is huge. How does
I
this
know. I
help-
want to buy
how
into that documentary.
How does this help the defense if it's not so painfully obvious?
You know, it actually, so how I think it can help the defense, and one of the things I want to talk about is the fact that the defense actually filed a motion for a different venue. No, no, no. You don't want a different venue. She just said this whole town knows about these sex parties. You know that's not going to come in at trial. The only thing that could potentially come in is if what the sheriff had knowledge of. So if he had knowledge that his daughter, perhaps, let's just say maybe that was something about the text, if he had knowledge of something and that helped formulate whatever that heat of passion was, whatever his mens rea was, his thought process, that would be relevant. But all this other sex parties and everybody knows it? No. But listen to her. She says everybody in the town knows about it. So why do you want to change a venue when that jury pool is going to know all this stuff that you wouldn't be able to bring up in front of the jury because it's not relevant? The state's going to try and keep it out. But boom, you have it already.